Good afternoon. Not legal advice. Please subscribe, comment, share, and throw out any specific topics that you might like me to discuss in future videos. This is really intended for educational purposes and to permit you to feel more comfortable and ask better questions to your lawyers. This video applies to both my and all litigation involving MMTLP and any and all litigation involving Tsla or you personally, whenever you will be involved in that. Hopefully you will get to avoid it, but if you are involved or if you have to speak to somebody that's involved, my goal is to try to kind of make things easier for you to understand and to deal with the particular language. At the end of this video, at the very end, I'll briefly comment about the NextBridge press release of February 23rd, and I'll address it then. So as I've indicated in prior videos, a case starts off with the filing of complaint, which is basically the claim document. And then there's a series of sparring rounds between the parties, arguing about procedural issues. Once or if we get past that stage, then we can begin the discovery process. And we all have heard of that in various ways, although I don't know if we specifically have addressed it specifically, but generally it's been discussed. So the discovery process itself is both written and oral, and in effect it attempts to ascertain the testimony of the witnesses and parties and evidence and documents under penalty of perjury and their full positions, as well as locking parties into their positions, and this will be especially relevant as to depositions. So it's fact-finding, but also to kind of make sure that everybody has taken a position and it will be harder for them to contradict that at a future point. So typically about 30 to 60 days after a case is filed in state court. In federal court, it'll be different because there's different requirements pre-discovery. But typically in a state court action, 30 to 60 days after I would file an action, I would initiate written discovery. And it would be in the form of one of three devices. It would be requests for admission, special and or form interrogatories, and requests for production of documents. These are only provided to the parties to the litigation. And the parties, when people refer to parties, those are the actual named participants in a case. So if you look at the first page, they would be the individuals or entities that are listed on the box on the left-hand side of the first page. To get documents or testimony from a non-party, a non-participant, you'd have to use a subpoena, so that's one major difference. And if a subpoena is used or any document is personally served, a process server actually has to go down and personally deliver that document to the individual or entity. So now getting back to the example. So for example, it's day 45 and my office serves on, let's just make up a party, Fidelity, requests for admissions, interrogatories, and requests for production of documents. They can either be served by mail or nowadays, most of the time, electronically. And once that service happens, that's when the response clock starts to run. So from that point in time, they have a period of time, depending on where you are, which jurisdiction, to respond. In California, it would generally be approximately 30 days. So now I'm going to specifically go over each of the devices quickly, just so we understand what they are and what they're designed for. So requests for admissions are devices used to establish preliminary facts. For example, my request for admission number one might be admit that you were born in Los Angeles. So it's a way to establish that kind of fact in a cost-effective manner and without requiring much effort. You also can do it as to documents. So you could attach a document like a contract and state, admit that Exhibit A attached is a written and true and correct copy of the contract between plaintiff and John Doe. So that's another way it can be done. The response would be in writing. There can be objections. Objections would be on the order it's vague and ambiguous, unintelligible, seeks attorney-client information, those kind of objections. And so the objections can be asserted to the requests. If there's no compliance, there's a meet and confer period, letters exchange, and eventually, if there's no agreement, then there's court, and a court will issue an order and may order monetary sanctions. The second item that I mentioned was interrogatories. They're special and form interrogatories. These, again, are written questions directed by parties to parties, and either they ask general questions or they ask very specific questions. So in essence, there's two types of interrogatories. There are the ones created by the state or the federal government that ask very general questions. Example, are you a corporation? And these are, in fact, the form interrogatories. Then there are special interrogatories, also served in a written form, that ask very specific questions to parties that relate more to the dispute at hand. As an example, please identify all persons who discussed naked shorts with Ari Rubenstein regarding MMTLP from January 1, 2020 to the current time. Again, there could be objections, a negotiating period, and then court appearances and sanctions. It can take several months, but ultimately you'll get a response from a court, and if they're appropriate, there'll be an order to comply. Finally, there are requests for production of documents. Just like their title, they request that a party provide a written response and documents in response to requests outlined in various categories. For example, please identify and produce all documents sent by FINRA to Ari Rubenstein with regard to MMTLP from January 1, 2018 to the current time. That would be an example of a category of documents that would be required to be responded to, and any corresponding documents that applied would have to be provided. Again, there could be objections, negotiations in court time, but eventually there will be some order requiring something to be produced. So after we get the documents and answers to interrogatories and responses to requests for production and the documents, we synthesize it all together and figure out the facts and use it and all of that information to prepare for and use in oral depositions. So it generally goes in the order of written, then oral discovery. I will address depositions in another video either later this week or early next week to show you how that fits in the order of proof and where it goes in terms of trial. Lastly, I saw the 223 PR from NextBridge. It appeared to be directed by lawyers and designed to focus attention on the brokers and AST. In and of itself, I did not find the press release regarding MMTLP to be meaningful. In my view, as March 1st is tomorrow, and my last tax notice from Fidelity said I would receive an updated notice March 5th, we will see if that date is meaningful or just another placeholder. I know others have discussed taking action or further action beginning March 1 also, so it remains to be seen when that will begin and to the extent, but I encourage it from anyone to add additional pressure. However, as I have previously stated, we cannot predict a precise date for a conclusion. Everything else is speculation. It sucks, but it's not unusual, and we will continue to fight either way. Be well, stay strong, stay proud.